I'm here with Martha Coakley. Of course, most of our viewers know her as the former Massachusetts Attorney General, but she's also been a former federal prosecutor, and right now she serves as of counsel at Foley Hoag. Thanks for your time, as always. We really appreciate it. All right, let's start with some legal minutia first. He needs a lawyer. He needs some lawyers that are actually admitted to the bar in Florida, right?
Yes, and he's had a little bit of difficulty, it seems, getting some because he's gone through a string of lawyers for different reasons. They waived that requirement today, so he had his lawyer from New York, as I understand, represent him at the arraignment.
Let's talk about this judge, Judge Aileen Cannon. We know she ruled favorably for the president earlier in this documents case. She was kind of scolded by the appellate court that sits in Atlanta, which covers the Southeast. Do we think she's going to stay on this case? Will she stay on the case, or can they swap somebody out?
Well, she could recuse herself, but if she does stay on it and behaves in the way that Jack Smith finds similar to what she did in the investigation phase, he could move to have her recused or removed from the case. I do think this is a different ballgame, though, and she may have gotten a lesson from that slap, as you said. Yeah. It was a pretty harsh decision. She's a new judge. She may just not know enough, but my guess is she's going to watch this closely.
You mentioned Jack Smith. He was in the courtroom today. What signal does that send?
Well, it's important. This is his case, and he wants to give a signal that they are going to play by the rules. The rules have changed now. Mr. Trump, former president, is not in charge anymore, but he and his prosecutors and the judge are. And that's a very different set of rules, I think, for this former president to have to abide by going forward.
All right, we talked about this indictment a lot when it was unsealed late last week, but let's compare this case to the case he's already facing in state court in New York. Obviously, no one wants to face a criminal case. Which is more serious, though?
So this is clearly more serious because of the federal statutes involved, the penalties involved, the strictness by which the whole trial will proceed with a federal judge. So I think the other was a kind of case that might have been brought against anybody. Indeed, the DA said that. It was a documents case. It's not unserious, but this one has clearly more consequences, both in procedure and process for them.
Now compare this, I'm going to ask you to look into your gazing ball, if you will, your crystal ball. Compare this, there's a lot we don't know about what's still to come potentially in both Georgia for the election, possible election interference case there, and then also the other part of the Jack Smith investigation, which has to do with what happened on January 6th. Those could also present a lot of legal jeopardy for the former president.
They could, and we know from the crystal ball already that from the special grand jury, the inquiry grand jury before the Fani Willis return in August
in Georgia,
about that case and trying to find votes. He is on tape on that also. Find me this number of votes. And we, as we've said, that's really important evidence, his own voice indicating that he knows what he's doing. And the other part of this Jack Smith investigation that the D.C. grand jury is looking at also will have very serious consequences for him should he be indicted, particularly on a range of charges, as we've seen for those who stormed the Capitol.
And then one last question, timing. Could they get a trial in before the election, which is, about 17 months away now?
They could get a trial in. It's a 70-day speedy trial rule in federal court. It won't happen within 70 days, but all of the proceedings will not be completed. Even if he was tried, there was a result, and he was convicted, there will be time for sentencing and appeals, and most likely that will not be completed before the next election.
And he would, in federal court on these kinds of charges, you don't go to prison while you're appealing generally, is that the case?
For a defendant like this with no record, not likely to flee, I think it's highly likely that even were he to be convicted, his sentence would be stayed pending appeal.
All right, great info, Martha Coakley. As always, we appreciate it.